first sentence of 16385A says, any registered voter of the county may challenge the right of any person to register, remain registered, or vote in any such county. If it applies to registered voters, why do you think that applies to a county board or the state board?
Well, first of all, the members of the county board and the state board are registered voters. The purpose of the statute is to allow...
Well, but we have independent authorities
of course,
level.
Of course.
Not as just as citizens. We have much more authority than that.
And responsibility, for sure.
I understand our responsibility.
But the purpose of the deadline is to establish. I mean, we went through all these in opposing counsel's brief, the questions about due process, what sort of notice, what sort of hearing, all of that. Those are to protect the voters of the state of North Carolina whose ability to cast a vote has been challenged, to allow them an opportunity to be heard. The same due process concerns apply whether it's a registered voter who's applying and challenging an individual voter or a member of the Board of Elections. And so the answer to your question is that provision applies to any specific, voter-specific challenge. And it's precisely because of the due process concerns. If you would allow the members of this or any of the county boards to challenge, then you've really just nullified the state statutory scheme for imposing deadlines and ensuring that there is appropriate due process concerns. So I would, as I mentioned before, Executive Director Strack testified in federal district court that same-day registration ballots are retrievable because they're absentee ballots, but the law doesn't allow them to be retrieved unless they are challenged. That was her testimony. And then on redirect, she was asked again, and she confirmed that an absentee ballot would count unless the voter was challenged on election day. And I quote, "And if that voter is not challenged on election day, that ballot would count," close quote. That's Ms. Strack's testimony under oath, and Judge Schroeder, and I won't read the language, but relied specifically on that testimony in the federal decision on April 25th in the North Carolina State Conference of NAACP versus McCrory.
Excuse me, Mr. Hamilton. In the case where voters
If a voter was given the wrong ballot style.
No, I'm talking about an error on the part of the board wherein a large number of voters are given the wrong ballot style.
Sure.
Like have wrong races on it or something?
That essentially.
As I understand your question, they're in a county and they're given the wrong ballot style, allowing them to vote on elections that they're not entitled to vote in. Is that
exactly?
Okay. In that situation, if there were a sufficient number to cast doubt on a legitimate doubt on the outcome of the election, then that would be an appropriate irregularity to consider under a protest. That's the kind of thing, but that's not a challenge to an individual voter's qualifications. For those sorts of challenges, you can't just staple a list drawn from some commercially available and unreliable website and challenge all those voters en masse. That's just a complete evasion and ignoring of the statutory scheme that North Carolina has embraced. And I think that's the problem that we have here. If you look at the argument that's been presented in front of you, if you look page through the brief, there's almost no discussion of the statute. There's no discussion of what was the legislature trying to do, what's the purpose of this, what are the deadlines. And instead, there's some citations to various cases, and then sort of this, let's just make up the rules of that seem fair to me, or that might seem fair to you, but that's not your role, with all due respect. The legislatures thought about this and set up a procedure. Certain kinds of challenges can be brought pursuant to the challenge process in Article 8. Others can be brought as a protest. But they're very different things, and you can't just style individual challenges as a protest and ignore the legislative scheme. That's not consistent with the plain language of the statute, It's not consistent with the way that we interpret statutes to render across the country. We pointed out in the brief the cases from Minnesota, Louisiana, Delaware, all cases in which the courts have said, geez, here's a ballot that probably shouldn't have been counted, but the challenge was made untimely. Bell v. Ganaway, for example, in Minnesota, the court held that.
Where is that in your brief?
Which page? Bell v. Ganaway is cited on page 6 of our brief.
Thank you, Counselor.
And there they said that the failure of an absentee voter to properly execute his affidavit of residence and eligibility would require that the ballot be rejected if timely challenge is made. But because there was no timely challenge, the court was compelled to hold that the contestant's challenge to this absentee ballot came too late, where the ballot had been deposited into the ballot box and commingled with all the others. The same rule is applied under New York law. Court may not entertain a challenge to absentee ballots where no protests or objections have been made to them on election day. Louisiana and Delaware have the same rule. In the few minutes I have remaining, let me address the second and third questions. The second question was whether the basis for a determination of ineligibility may be brought as a protest of election under Article 15A. And I think that again, North Carolina law directly addresses the issue and forecloses this end run around the challenge procedures built into Article 8 for many of the same reasons that we've been discussing. That Article 8 it builds in a series of due process protections for the voters, allows time for the voter to be heard, and for the county boards to many of these challenges, if styled, considered as a protest under Article 15A, would be untimely in any event. The statute 182.9B4A requires that protests be filed with the county boards of elections before the beginning of the county board of elections canvass, if it concerns the manner in which the votes are counted or the results tabulated. And many of the county boards here have already begun their canvass. So I think this board should take the opportunity to make it clear. If you've begun the canvass and then a protest was filed, it's untimely. Second, even for protests filed in a timely manner, the protest must be dismissed unless there is substantial evidence of any violation, irregularity, or misconduct sufficient to cast doubt on the results of the election. That's 163, 182.10D2C. And to allow a protest to proceed, the board would need to find substantial evidence to meet this standard, that it's sufficient to cast doubt. Read together, these provisions make it clear that a protest must be dismissed unless the facts alleged could change the result of the election. And here it's not close. At most, taken together, all these protests that have flooded the counties add up to a few hundred votes. The current margin, according to this board's website, is well over 6,000 vote margin.
Sir, that's just in the governor's race. There are other possibly council of state races that may be a closer margin. Is that correct?
As I understand it, there's another race. I can't quote the exact total. I think it's more like a 3,000 vote margin, but it's still well outside. Even if every one of these allegedly illegal votes was actually found to be illegal, and even if every one of them went for the losing candidate, it still would cast doubt on the outcome of the election. There's just not enough here. So it's fine. I'm not suggesting that the board shouldn't address these issues. They certainly should, but not at this point, and not in holding up the canvas of this election.
How many of the protests, or whatever we're calling these things, were actually filed after the quote, beginning of the county Board of Elections canvas meeting. Not the process, but that would have been on the 18th. How many were
I'm sorry to say that I can't answer the question. I don't even think your staff can answer the question because some of the counties haven't sent the protest to this board, and I don't understand quite the reason why we don't get notice of the protest directly. So we've been
We don't understand it either because they're supposed to report it within 24 hours.
That's correct.
Yeah, so everybody out there here listening to this, county boards are supposed to report it within 24 hours. Mr. Knight certainly knows. Mr. Knight, would it be fair to say that you know how many protests have been filed on behalf of the Republican Party?
I believe it's 52.
You believe it's 52? Can you tell us how many, can you answer, do you know how many of those were, at Mr. Chairman's question, how many of those were filed in a timely manner?
No, sir. Some, these are all individual protests, and some of them, I realize that some of them dealt with it. No, sir, I don't know.
He said no, he doesn't know.
Yeah, is your mic, does it have a little green thing turned on? Does your microphone have a green button?
The microphone does not have a green button.
Does it have any kind of button? Good. Mine has a button that turns green when it's turned on. Can we?
I think I answered his question, so.
Well, we can hear you now. Can everybody hear him now? Okay. All right. Proceed,
Mr.
Counselor.
Chairman, that was about 3 minutes.
Okay. 3 minutes, Counselor.
The third question that the board asked was what procedural protections should be followed to ensure due process if these protests were to be considered. And the easy answer here is North Carolina has already addressed and already built in a process to address these. If it's deceased voters and the voters appear on a list of deceased persons provided by the Department of Health and Human Services to the State Board of Education, they can be removed from the registration lists. County boards may also remove individuals identified as deceased by a signed statement of a relative. Felons or active felons or those voting out of state or voters accused of being dead who are not on those lists, North Carolina has a statutory system to allow due process to the individuals to be heard before they're removed. But there's a process to go through to clean the list and do list maintenance. There's no process for considering such challenges as a protest of the election after the fact, and for good reason. At some point, you have to have finality in an election. There was a list that was apparently generated by a staff member in the Board of Elections office on his own initiative. That's a helpful exercise when done in advance of an election so that you can challenge voters and remove them from the list when there's still time to provide appropriate notice. But it can't be used now at this point. Moreover, the information submitted in support of many of these protests have, upon investigation, proved to be untrustworthy, which demonstrates the need for this very procedural protection.
But Mr. Hamilton, that statement you just made, the fact that some boards, approximately 5 or 6, I guess depending on who you ask, because it seems like we don't always know, if a majority of them have been dismissed at the county level, does that lead you to believe that the process and the statutory framework is working as it's been interpreted by at least those counties?
Well, I think the process, the correct outcome for these individual challenges styled as protests is to dismiss them. So to the extent that the county boards have dismissed them, absolutely. The process is working because the county boards have read the statute, understand the structure, and viewed these as untimely individual challenges and dismissed them. And that's appropriate. So respectfully, I would submit that the board should conclude that county boards of elections may not retrieve ballots and discount the votes of individuals if no challenge is timely brought under Article 8, and would encourage the board to provide appropriate, consistent guidance to the county boards of election. Thank you so much.
Thank you, Counselor. Let's kind of not comment in the audience, please. No applause and no boos. We have a choice now. Under the amended agenda, the Cooper and the Democratic Party are entitled to a 10-minute rebuttal, but if you'd like to go after the Southern Coalition, I'll leave that up to you, Counselor.
I have nothing to say in rebuttal to my own argument, so perhaps it makes sense.
Well, I'm just trying to go by the...
No, I appreciate that. I appreciate that, Mr. Chairman,
So-
and I think it would be appropriate for us
Well,
to...
I do too.
Thank you.
I didn't want to change the order without y'all being okay with that. Okay. Could the Council for Southern Coalition of Social Justice come up and you have 20 minutes?
Good morning. My name is Allison Riggs. I'm a senior voting rights attorney with the Southern Coalition for Social Justice in Durham. We appreciate the board's consideration of our memo and granting of our motion to be heard here. Briefly, because I don't want to repeat what I've detailed in the memo submitted yesterday, there's just a few points that I want to address, specifically with respect to the second two questions posed by this board. Should this board give guidance to the counties that they may, under the protest statute or their canvass authority, consider some of these challenges that have been posed? We wanted to raise a very real concern we have that such activity would violate the National Voter Registration Act, which prohibits systematic list maintenance activities in the 90 days prior to an election. While we are after the election, I think the statute would certainly encompass that time after the election and before the certification of the canvass. That is, doing systematic list maintenance after votes have been cast but before the election has been certified would fall under the prohibition imposed by the National Voter Registration Act.
As it relates to which category of voters, are you talking about the dead, the felons, or the people that vote in two states? Which, or all of them?
All of them, and let me explain why. Because what is prohibited list maintenance is anything that is not individualized and rigorously examined on a one-by-one basis. So when you have situations where either challengers or the IT department of the State Board of Elections doing database matching to try and to determine eligibility of voters, this is a systemic process of list maintenance. So looking at within the 90 days or after the election but before the canvass, doing matching to try and identify voters who have died on a systematic basis would be prohibited by the Act. If I come up to a county board and say my neighbor who I know passed away after voting, that would not be a systematic effort. But the challengers are not doing that. They are, with respect to the felon lists, the alleged felon list, they are doing database matching that is rife with error. With respect to this alleged double state voting, they are doing database matching that is, again, rife with error. And there are two court cases that I think this court should look at to understand why this is problematic under the NVRA. The first is, both are cited in my brief, the Archia case from Florida, where the 11th Circuit in 2014 said the state's attempt to remove ineligible non-citizen voters before the election violated the NVRA, regardless of the fact that these voters may have been ineligible. The data was not certain enough, and the time was too short to identify errors. The 11th Circuit said Congress decided that in such a situation, the risk of disenfranchising an eligible voter outweighs catching a voter who was ineligible. That's Congress's determination on the relative balancing. Likewise, Judge Biggs in the Middle District recently said that private parties can, through challenges, start initiating what amounts to county or state list maintenance. In that case, these were pre-election challenges, but they were mass in number within the 90 days and not based on any individualized understanding or rigorous inquiry. I'd also like to address something that came up. I think it was Mr. Malcolm mentioned in the meeting on Sunday. What do we do, the counties, the state board, what do we do when this information falls in our lap? And, for example, the Burris analysis. And this is what I think is important to understand here. This information that may be falling in your lap is not neutral, it is not uniform, and it's not non-discriminatory. The information brought by the protesters is largely inaccurate. It appears to be targeting, at least the felony claims, appears to be targeting African American voters. Vast majority of those challenged are African American. Many of them are wrong and are people with misdemeanors or people who are just the wrong people. But to take those discriminatory protests and then rubber stamp them by saying, I'm going to consider these because these are what fell into my lap, it's going to lead you down a road where you're going to be more likely to violate the Voting Rights Act. The other thing to keep in mind, too, is that if we go down this road where these protests, these untimely challenges styled as protests, where there is no possibility that they affect the outcome of the election, if we allow these to proceed, I think it's opening a floodgate that's going to be very difficult to manage election administration with. So, for example, it opens the door for groups to start challenging every possibly inappropriate, at least borderline, denial of a provisional ballot, the discounting of a provisional ballot, even if it doesn't change the election outcome. Because we could say, well, we just haven't found enough of them yet to change the outcome of an election. And so it never ends. The county boards will be drowning in these protests and will never be able to have orderly election administration.
Ms. Riggs, I'm looking at 52 USC 2507. So help make sure I'm clear about what you're saying. Because when I look at paren A, paren 3, it clearly says, provided that the name of the registrant may not be removed from the original list, except in B, as provided by state law by reason of criminal conviction or mental incapacity. So if I go on to read over in paren 4, it talks about the death of a registrant. If I go on to read 5B, it clearly, if you're on the plain reading, it says any state program or activity to protect the integrity of the electoral process by ensuring the maintenance of an accurate and current voter. And it says, as you stated, shall be uniform. But the way I read this in totality, when it talks about the 90 days prior, it's specifically not including death and felons. Are you saying I'm misreading that?
I think it means it still can't be systematically. It means that they can be individually removed.
Okay.
So this is the same issue that the 11th Circuit grappled with, because Florida state law allowed for the removal of voters who were ineligible because they lacked citizenship status. These are voters who can, one by one, be removed, but they cannot be systematically removed, particularly in a non-uniform way.
Do you know how many felons have been protested, or we're using these words interchangeably, challenged, protests? How many county boards in the state have taken up felon matters? Do you know the answer to that?
How many county boards in this state? So there were about 47 or 50 total felon challenges, and I believe most of them have been dealt with already.
When and how have they been dealt with?
So in Wake County there were 3. 2 were clearly the wrong people, juniors and seniors. mixed up and one was not. Guilford was, over half of them were people who were actually only convicted of a misdemeanor, also African Americans. So they are looking at these and they are finding them almost completely lacking.
So would that lead a reasonable person to believe that they're doing an individual analysis and that they're doing what they're supposed to be doing?
I think the county boards so far are doing an individualized analysis, but I don't believe the challenges are being brought on an individual basis, and that's part of the problem. If you look to Judge Biggs's opinion in the NVRA case, the basis of the initiation of the list maintenance procedure really needs to be individualized. But I do think it's important at this point to say that the county boards are doing a good job so far. And North Carolina is the envy of the country when it comes to election administration. There is absolutely no evidence of systemic voter fraud, and we do an enormous disservice to the hundreds, if not thousands, of North Carolinians who work tirelessly as election workers when we elevate spurious claims like this and imply that they in any way cast doubt on the election that we have just conducted. The county boards are in large part doing the right thing, dismissing these protests. But whatever this board does from this point on, the single most important concern that needs to be dealt with is the board ensuring that due process rights of every North Carolinian are safeguarded. And so if you don't instruct the counties to dismiss these as untimely challenges, you must in emphatic terms explain to the county boards that every voter whose ballot is at dispute needs to be afforded the right to come and defend him or herself, to face his or her challenger, and explain to them the very high standard of proof required to discount a constitutionally protected ballot cast.
How would you have us, Ms. Riggs, handle these absentee ballot mill allegations? 4 or 5 counties, there's an allegation of absentee ballot mills. This handwriting issue, can you comment on that, please?
I can, because the counties are dealing with these well. Last night, Greene County unanimously dismissed allegations that there was an absentee mill going on. They pulled the voter registration forms and the absentee envelopes, and the board went through each and every one, exact match. These are specious claims. They're not well researched. They're unfounded. The counties are in control of this, and they're untimely to begin with. But I think we have to have some faith in the fact that the counties are recognizing that these are bad claims. I ask them, otherwise I've taken up enough of your time. Thank you.
Thank you. Well, I guess that brings it back to, we have a 10-minute optional rebuttal for
Wake County Bar, so I do not need to be admitted
Can
pro
you
hoc.
get closer to the mic? Yeah.
Honorable board members, I want to make a couple of points in response to the arguments by the Cooper Campaign and the Southern Coalition for Social Justice. Although I have heard the phrase politics makes strange bedfellows, I don't think I ever expected to hear the SCSJ argue in favor of voter list maintenance, although there are first times for everything. The argument that the Cooper Campaign and the SCSJ are making to you is that no protest and no challenge to ballots for which irregularities are found after the election occurs can be brought. Their argument is essentially due process is actually no process for the irregularities that have been found here. That is not within the duties and responsibilities of the State Board and the County Board of Election that has been delegated to you by the legislature. The statute provides that the North Carolina State Board of Elections, quote, shall investigate when necessary or advisable the administration of election laws, frauds, and irregularities in elections in any county and municipality and special district. This is General Statute 163-22. There is no timing restriction on this board's authority to make such investigations. Now, the Cooper campaign and the SCSJ's position is essentially that because the protests at issue were not brought under the Article 8 challenge framework, they are untimely and should be dismissed. What I would submit to this board is that it has a responsibility to look into the allegations that have been raised by these protests and determine whether or not the allegations are true, whether they have merit, and whether they warrant any remedy that the county boards determine is appropriate in this circumstance.
Mr. Branch.
I'm sorry, go ahead.
I'm sorry, Jeff.
By what statutory authority? Article 15A?
Yeah, I'm looking primarily right now, Judge, at 163-22. Essentially, our position is that the State Board has plenary power over this process. It has been delegated the authority and the duty to regulate elections in the state of North Carolina, and abdicating that duty in the face of indications of possible irregularities in some of the voting that has occurred in this election, we believe would be irresponsible.
Are you alleging that this board has done that, sir?
What I'm saying...
Yes or no? Are you alleging that this board...
The board has not made a decision yet, sir.
Okay. Are you alleging that any county boards have not properly followed the hearings that have been held? Are you alleging that those have been occurring improperly?
I don't know if the hearings have been occurring improperly. There have been some counties that have dismissed for lack of probable cause some of the protests. What I am saying is that this board has the responsibility to investigate the allegations that have been raised. Now, Ms. Riggs made a great point about Greene County. Greene County received a protest, according to her, over the absentee ballots. Its board members went in and reviewed the signatures on a ballot-by-ballot basis, determined that there was no fraud there, and dismissed the protest. That is what should happen on a county-by-county basis. The county boards, as determined by the State Board in the hearing on Sunday night, should act as fact finder with regard to the issues that have been raised in each of these protests. And dismissing the protests before the counties get to act in that fashion would be inappropriate, and I believe would undermine the public's the public's faith in the regulation and conduct of elections in this state.
What do you mean by that, sir? What do you mean dismiss? Tell me what you just meant by that.
Well, look, Ms. Riggs' point with regard to these protests is that the protests should be dismissed writ large because they are untimely. Ignore the issues that have been raised, dismiss the protests, and just certify the vote as it is.
Are you representing to us now that you believe that has been occurring? If you are, tell me which counties that's occurred in.
We are here today to discuss the process by which the State Board will consider these protests. Our position is that the protests should be considered on their merits and not dismissed on technical procedural grounds, and that there is statutory authority that has been delegated to this board that allows it to exercise jurisdiction and require the county boards to investigate these issues on the merits.
And that is my question. If we relied on 163-22, that does deal with the authority given to the State Board, correct?
That's correct.
And there would certainly be arguments that would be made that it would be extremely difficult for the State Board to conduct factual hearings of alleged irregularities in 52 to who knows how many eventual counties. Do you contend then that we have the authority to have the county boards conduct factual hearings for the state board under our authority in 163-22?
Yes, I believe that the county boards have that authority and that responsibility under the protest framework. Now remember, the Cooper campaign and the SCSJ's position is that all these protests should be dismissed as untimely. They should not be heard at all. All the McCrory campaign's position is that these protests need to be heard on the merits. An investigation needs to be done by the county board. Now, I think there is an inherent challenge, and Ms. Riggs is right. The individuals that are bringing the protests don't necessarily have the right tools and ability to determine on their own whether or not the challenged issue in the protest is valid. That responsibility, we believe, resides in the state board and the county boards of election. If these issues come up and there is probable cause to believe that there is an issue, an investigation needs to be done with regard to whether the issue is valid. And you know,
I'd like to ask you about that, Mr. Branch, if I could. On page 14 of the brief that you all submitted, about 5 lines up from the bottom, start in the middle of that paragraph, middle of that sentence, it says, in paren 2, scheduling the preliminary consideration meeting called for under NC 182, 163-192 to occur as soon as the County Board of Election staff has concluded their investigation of the protest and all relevant information from the State Board of Elections has been received. Just like I asked Mr. Knight, show me where in the statute, sir, it says that a county board, when they receive a protest, because it doesn't say it, but I want you to, maybe I missed it.
Mr. Malcolm,
Let me finish. Right. Show me where, just based on the 4 corners of a protest being submitted, that the county boards are supposed to go out and investigate that before the preliminary hearing.
That is part of the responsibility that has been delegated to the state board, and we would argue by virtue of that to the county boards in their administration of the electoral process in North Carolina.
Sir, that's not what the statute says.
Well, can I give you an example here?
Yeah, sure.
The felon voting example from the last board meeting, where the state board staffer identified 339 individuals who may have voted while inappropriately on felon status. My understanding is that the number of protests that were filed on felon voters was less than half of that. The issue with regard to the felon voters is the State Board of Elections has a far greater amount of data available to it that allows it to determine the veracity of these issues. And so what we would think is appropriate is that the Board of Elections investigates whether or not these issues that have been raised via the protest process have merit.
Got 1 minute left.
If they don't have merit, dismiss it. If they do have merit, then there's the question of the remedy, which we'll stand on our brief on with regard to whether or not the ballot should be pulled. I have one final point I want to make, and then if there's any other questions. The outcome of these protests absolutely could affect the outcome of this election. It is unclear, so the investigation has not been done on a number of them. It is unclear how many ballots are actually involved with regard to how the protests that have been raised. And we understand that there's been a same-day registration protest filed as well. And so to the extent that the Cooper campaign and the SCSJ is contending that the board shouldn't look into any of these protests solely on the grounds that the protests would not overturn this election, we would submit that that is inappropriate.
Thank you.
Thank you for your time.
I have a question. Would you find a difference between an irregularity and a challenge? And if so, would you describe what irregularity has occurred?
Are you okay? And I believe that you're asking this question with regard to all of the protests that have been raised.
Yes.
Rather than parsing category of protest by category of protest, I think we would say that the State Board has the plenary authority under Article 163 regardless of whether you want to parse hairs, is it a challenge, is it an irregularity, regardless of the issue, the State Board has the authority to investigate the issue, and we believe that it should evaluate the merits of it so that every legal vote gets counted. Thank you.
Thank you. The Cooper campaign and the North Carolina Democratic Party have 10 minutes. Mr. Hamilton.
Thank you, Mr. Chairman. I'd like to just make a couple of points. First, I didn't want to overlook the fact that there is a numbered memo, 2016-09, directing county boards that absentee ballots should be counted unless they're challenged pursuant to Article 8. Election day and was properly challenged no later than the time set by the statute. And then, of course, it also indicates that notice must be provided to challenge voters under the provision governing election protests, and for good reason. Those challenges are precluded by the plain language of the statute. Second, if this board were to say that voters, campaign citizens of the state can ignore the provisions and deadlines of Chapter 8 and instead repackage individual challenges to voters as protests, you will open the floodgates. You will not only be disregarding the process created by the North Carolina legislature to manage this process, afford a fair opportunity to challenge prior to the day of the election, and protests to be filed where they'll change the outcome after the election. But if you break down this barrier and allow things to be repackaged, then you're going to see a flood of these things happening every time. Why would you why bother challenging anything in advance of the election? Why don't you just wait and see if it's going to make a difference? And if it's a close enough election, then we're going to be encouraging people to start filing these sorts of post hoc processes. And this is not my judgment. This is the judgment of the North Carolina legislature. This is not the way we run an election in this state, or candidly in almost any state. And then you rule on it in advance. Now, after the date of the election, sure, if there's an irregularity, this board and the county boards of election have plenty of authority and I believe responsibility to investigate irregularities. But unless, under Article 15, unless it's going to change the outcome of the election, then you can't view it as a protest. And there's a good reason for that, because if it's not going to change the outcome of the election, then let's get on with it. Let's finish this election, and then let's address whatever issues that we need to address. Prosecute an individual who may have cast an improper ballot if there's grounds to do so. Clean up our registration list to make sure that the next time we do this, we don't have the same problem with these individuals. That he thought that we were making the point. Of course, you can bring it under Article 15. That's the whole point of it. There is no obligation. I believe one of the questions from the board pointed this out. There's no obligation for the county boards of election or their staff in the middle of a canvass, simply because somebody files a piece of paper saying that they protest or raise a question without any evidence, that we're then supposed to stop the canvass and go launch an independent investigation to try and find evidence for an unsupported allegation. That's not the way the process works. The statute says the very first step upon receiving a protest is a probable cause hearing. A probable cause hearing is an opportunity for the protester, not the staff of the county election board, to come forward with evidence, testimony, documents, and show the board this is not just a piece of paper. This is not just a guess or a hypothetical, but there's actual evidence and there's probable cause to believe that this protest not only is supported by the facts, but also would change the outcome of the election. If they can't show that, the process ends there. And it's not, the filing of the paper doesn't somehow impose an obligation on the board or its staff.